Hi friends, I am your friend Advocate Namish Nigotia and you are watching my YouTube channel Legal Advice for Everyone. Friends, as you are well aware that every fact which one person alleges in the court, he is required to be proved through his cogent evidence. But there are certain facts as per the Bhartiya Sakshya Adhiniyam which is not required to be proved. Which are those facts? Where it has been mentioned in the Bhartiya Sakshya Adhiniyam. So today we will study about those facts which does not require to be proved through the evidence. It is section 51 to section 53 of the Bhartiya Sakshya Adhiniyam 2023. In the old enactment, the Indian Evidence 1872, the provision is analogous to section 56 to section 58 of the Indian Evidence Act. So we will take one by one section 51, 52 and 53. Before I proceed further in this video, if you have not subscribed my channel, please do subscribe my channel, and if you like my videos, kindly share my videos. Thank you. Now section 51. This chapter 3rd of the Bhartiya Sakshya Adhiniyam 2023 says facts which need not to be proved. First we will study section 51. Facts judicially noticeable need not be proved. Section 51 says no fact of which the court will take judicial notice need be proved. Now the question arises, which facts the court will take judicial notice, and the answer is in section 52 of the Bhartiya Sakshya Adhiniyam. I would like to clarify that section 51 of the Bhartiya Sakshya Adhiniyam is analogous provision to section 56 of the Indian Evidence Act 1872. Now we will study section 52 of the Bhartiya Sakshya Adhiniyam, which says facts of which court shall take judicial notice. This is very important and relevant because these are the facts mentioned of which the court shall take judicial notice, and one person need not to be proved through his evidence those facts. What are those facts? A. All laws in force in the territory of India, including laws having extraterritorial operation. Means all laws in the territory of India is not required to be proved. B. International treaty, agreement or convention with country or countries by India, or decision made by India at international association or other bodies. It does not require to be explained. It is self-explanatory that international treaties and agreements or conventions with country or countries by India. Now see, the course of proceedings of the Constituent Assembly of India, of Parliament of India and of the state legislature. Whatever proceedings taken in the Constituent Assembly of India, Parliament of India and state legislatures, the court shall take judicial notice of the fact. D. The seals of all courts and tribunals. If there is any seals of courts and tribunals, you need not to be proved this fact. The court shall suo motu take judicial notice of this fact. E. The seals of courts of administratory and maritime jurisdiction, notaries public, and all seals which any person is authorized to use by the Constitution or by an act of Parliament or a state legislature or regulations having the force of law in India. So these seals is not required to be proved before the court of law. F. The accession to office, name, title, function and signatures of the person filling for the time being any public office in any state, if the facts of their appointment of such office is notified in any official gazette. G. The existence, title and national flag of every country or sovereign recognized by the government of India. this is very important and relevant, that the existence and title of national flag of every country or sovereign recognized by the government of India is not required to be proved before the court of law. H. The division of time, the geographical division of the word, and public festivals, fests and holidays notified in the official gazette. Meaning thereby, if there are public festivals, geographical divisions has been notified in the official gazettes, it does not require to be proved by the evidence. I. The territory of India. J. The commencement, continuance and termination of hostilities between the government of India and any other country or body of person. K. The names of the member and officers of the court and of their deputies and subordinate officers and assistants, and also of all officers acting in execution of its process, and of advocates and other persons authorized by law to appear or act before it. An advocate need not to be proved that he is an advocate through the evidence. Now, L. The rule of the road on land or at sea in the cases referred to in subsection, and also on all matters of public history, literature, science or art, the court may resort for its aid to appropriate books or document of reference, and if the court is called upon by any person to take judicial notice of any fact, it may refuse to do so unless and until such person produces any such book or document as it may consider necessary to enable it to do so. Now we will turn to section 53 of the Bhartiya Sakshya Adhiniyam, which says facts admitted need not be proved. This is also very relevant and important. An admission is the best evidence as per the Bhartiya Sakshya Adhiniyam, as per the Evidence Act, and as per the rules of evidence. If a person admits anything, the opposite party need not to be proved that fact through his further and cogent evidence. Section 53 of the Bhartiya Sakshya Adhiniyam itself says facts admitted need not be proved. This provision is analogous to section 58 of the Indian Evidence Act 1872. What it says: no facts need to be proved in any proceeding which the parties thereto or their agent agree to admit at the hearing, or which before hearing they agree to admit by any writing under their hands, or which by any rule of pleading in force at the time they are deemed to have admitted by their pleading, provided that the court may in its discretion require the facts admitted to be proved otherwise than by such admission. This is very relevant and important. One has to learn that if the opposite party or his counsel admitted any fact by his words, by his writing, by his pleadings, that fact does not require to be proved. Now we would also like to study one relevant Supreme Court judgment that is reported in Civil Appeal number 2543 of 2009. The title is Ramdayal Jat versus Lakshmi Prasad. What happened in this case? That something has been admitted in the criminal case. The Supreme Court says that admission in criminal case is not admission in civil case, and you have to prove through the evidence. So in this video we have studied section 55 to section 53 of the Bhartiya Sakshya Adhiniyam 2023. Thank you friends.